What legal steps should I take now if my parent is in hospice and I suspect financial abuse or an improper property transfer? If you have a credible concern, the fastest next steps usually focus on three things: preserving evidence, stopping further transactions, and getting a court-supervised decision maker in place if your parent cannot give informed consent because of dementia. Start by gathering and protecting proof. Get copies of any power of attorney, deeds, bank records you can lawfully access, and hospice or medical notes that reflect your parent's mental condition and timing. Then do a quick public record check to see if a deed or a power of attorney was recorded, because real estate transfers often leave a paper trail. If your parent no longer has capacity and someone is using a power of attorney to move assets, a guardianship filing is often the main tool to put protections in place quickly, and in urgent situations, you can ask the court for interim relief to preserve the status quo while the case is pending. At the same time, consider making targeted reports. Law enforcement can investigate exploitation, and in some situations, county social services may be involved when a disabled adult is at risk. Also keep in mind that a will does not stop lifetime transfers, so the immediate focus is whether the transfer was valid, whether your parent had capacity at the time, and whether the agent had authority and followed fiduciary duties. Because delay can make recovery harder, the practical deadline is before the next withdrawal, beneficiary change, or deed transfer happens, so it is usually best to act promptly once the concern is credible.